Let me go ahead and I want to introduce one person, and then I'll let him introduce his team that is here. Sorry, my voice is changing. Um, was that you, Tamika? Thanks. Okay, so what we're doing tonight is something that, here we are, we're 20 years old as a church, and it's kind of occurred to me that we've never actually offered something like this before. And in recent months, I've been involved in multiple funerals that did not include much estate planning in advance. And and it can be a really sad thing. A lot of you have experienced it or seen this with families that someone passes away and there isn't even a will made, and all, and what initially looked like a fairly tight-knit family, can really go south, and people have a hard time getting along. I mean, you've seen this happen before. And so that's all part of why we started talking on the staff about we ought to offer something like this, just to help inform people and to help people have a contact with someone that's got some answers. And so we decided we were going to use LPL Financial. This is Jeb Graham that's going to be the primary one that's presenting this. He handles the staff's pension funds, and so we've known him for a couple of years now, and we thought, he's a quality guy. He can come in here, and what he can't do, his right hand and his left hand man will be able to do, in being able to fill you in on some of this information. So we're excited to be able to offer this to you, and there will be a question opportunity toward the end. So, Jeb, why don't you go ahead and come on up, and you can introduce the guys that are with you, okay?
Okay, that's a little better. Sorry about that. Came out here with a bang, I guess, huh? So, well, first off, thanks very much for having us out to talk about this. Thanks to Brad and Tracy and everybody at Crossroads, because certainly feel honored that you would ask us to come out and talk a little bit about estate planning, and hopefully this will be informative and interesting to you. To introduce everyone, this is Sean Shepard and Eric Wymore, and we're going to be passing out some materials here, some of it about estate planning. One of them is just a little bio about us and what we do. Full disclosure, we're not estate planning attorneys. I'm by trade a certified financial planner. We're all licensed financial advisors. So with that, although we're not estate planning attorneys, we deal with this sort of thing day in and day out. And like Brad had said, we certainly have seen families that have not planned for it and how that can impact you. And we've also seen families that have planned well for it and how that can impact their family, and how important it really is to make sure you have all your ducks in a row with estate planning. So with that, we're going to go ahead and pass some of this stuff out. As we go through, if anyone has questions, certainly feel free to raise your hand and ask a question. I think we're going to do a little bit of a Q&A session at the end. So if you want to, you can wait till the end, or you can certainly raise your hand and we can go through questions as we go. So, but to talk a little bit just about estate planning, I already mentioned how important that I think that it is. Just around the room, and I'm sure there's going to be a lot of hands, you don't have to raise them if you don't want to, but who here has had a close relative that has passed away within the last 10 years? Is there other people? And is there anybody here that was actually the executor on somebody's estate in the last 10 years? Thank you, sir. Yes? Okay. So anybody that's gone through that knows that it can be somewhat of a tedious process and that there's a lot involved with that. And so if you've been through it, you can certainly relate to some of this stuff. And really the point of this today is to show you what's important to get in line for yourself and for your family, and basically what documents you need to have on hand if something ever did happen to you, and just some things that you might be able to do today that would make the transition in the process a lot smoother for your survivors if anything ever did happen to you. So the presentation is called The Essentials of Estate Planning, and I'm going to go ahead and start clicking through, here's what we're going to talk about today. The agenda basically is, first off, we're going to go over some basics of estate planning, talk about wills and probate, and what those entail, trusts, alternate decision makers, which alternate decision makers would be someone that's a power of attorney or someone that has the ability to make medical decisions for you in the case that you're mentally incapacitated. And then also what you need to do to get started with estate planning. If you want, what are the first steps in kind of starting to get your household in order. So we'll go through the estate planning basics. So what is an estate plan in its pure form? An estate plan is basically a plan to manage your assets in the event that you are no longer around, meaning a plan for the disbursement of your assets and who you want those assets to go to if something ever happens to you. Another piece of estate planning is who's going to handle your affairs. You need to actually appoint somebody to be the executor of your estate, like we had talked about a little bit earlier. And then also special situations, which would be how do you give, you might have people that you want to give some of your stuff to. You also might have organizations. You might have your church that you want to give something to, or you might have a charity that is near and dear to your heart that you want to leave money to. And we'll go over a little bit of that sort of thing, and then also a little bit about how to pick and find an advisor to help you do that. So reasons for having an estate plan. So a lot of people don't know this, but if you don't choose who your money or possessions go to in the event of your death, does anyone here know who does choose that if you don't have a will in place? Or if the state? That is exactly right. So if you don't choose it, if you don't have a written plan as to what you want to happen with everything that you own, the state actually, they don't sit there and pick and choose where it goes, but each state has their own laws, and they have an order in which assets would go to in the event of someone's death. So it's very important, unless you want to default to what the state law has to say, then you want to have a plan in place on your own. And then another reason is to minimize legal complications and estate settlement costs. So it's very costly if you don't have an estate plan in place, or even if you just have a simple will. Simple will still goes through the probate process. That process can be very time consuming. It can also be very costly because you have to pay an attorney to help you with that aspect of your estate. And then also tax considerations. We'll go through a little bit of that as well. So, federal estate taxes. And I love how they start the presentation with this, because if anyone knows what federal estate taxes are, they don't apply to 99.9% of the people in this country, but it's what everyone always talks about is the estate tax exemptions. What the estate tax exemption is, a lot of people don't know this, but you don't pay federal estate tax unless you have a pretty high net worth when you pass away. So the exemption, actually I have the numbers over here, but if you're a single individual and you pass away, you don't pay any estate or federal estate tax unless you have over $5.43 million estate. And if you are a married couple, it's actually $10.86 million estate. Meaning the vast majority of the country isn't too worried about what the estate tax exemption is. But it was kind of funny. Do you guys remember, I don't know if anybody remembers, you guys remember who George Steinbrenner was? Anybody own the Yankees? I don't know if you remember, it made big headlines in the media back in 2010. Well, 2010 was an interesting year because the estate tax law was being revised at that time, and Congress basically couldn't come to a conclusion on it. So for a year, the whole year of 2010, anybody that died, no matter how much they were worth, did not pay any federal estate tax. Well, that just happened to be the year that George Steinbrenner, who owned the Yankees, who was a billionaire, died. So it was all over the news because it saved his family like $600 million or something like that. Something that's just, kind of crazy. So, but that's the estate tax exemption. So as long as you, as a married couple, don't have over 10.86 million, or as an individual don't have 5.43 million, you're not going to be on the hook for any federal estate tax. If you are over those limits, you're paying a pretty hefty tax on anything that's over that exemption. You pay anywhere between 40 and 50% on anything that's over that amount of money. And then also, whenever you do pass away, you do have to pay income tax. So if you've been working for the first 6 months of the year and something happens to you, your estate, whoever's settling your estate, is on the hook for the income taxes that you were on the hook for the time that you were working during that year. And I already went over the tax rates, but the income tax is going to be at your normal income tax rate, whatever that income tax rate would have been. Estate tax rates are at that 40 to 50% rate that I talked a little bit about. And this is a slide that we're going to skip, and you should be glad we're going to skip it, because part of it, each state also has the right to have an estate or a death tax as well. Kansas is a state that doesn't have that. In 2008, they repealed the estate tax, and in 2010, they repealed the death tax, meaning you don't pay any state, you're basically exempt from state estate taxes. And most people wouldn't pay them even if they did, because they're kind of similar to what the federal estate tax is. So one other thing is that you can pay, or you can also do this during your lifetime. And a lot of people don't know this, is that if you have money, and one way to get money out of your estate prior to you passing away is that you can pass money to individuals up to $14,000 a year per individual during your lifetime. So you can make lifetime gifts to an individual or to an institution or a charity that are not subject to any sort of gift taxes as well. Now, if you're going to gift a certain amount of money, same deal. If you get up to $5.43 million in gifts, then you're going to have to start paying taxes on any gifts over those dollars. So now that we're getting through that piece of it, we're going to start talking about the stuff that does apply to 99% of the world here in the United States, which are the planning tools that everybody can use, which are wills, trusts, gifts, life insurance, and then what they call joint owner property, or joint ownership property. And we're going to go through each one of these things in pretty good detail as to what exactly they are and how they apply. First thing I'll tell you, okay, another show of hands. Anybody in here own either an IRA, have a 401k at their work, a pension at their work, or own a life insurance policy? So probably most people have something like that going on in their lives. One of the most important and basic things you can do in estate planning is just making sure that you have named the beneficiaries that you actually want to benefit from those assets if anything ever happens to you. So IRAs, 401ks, and pensions, you always have to name a beneficiary whenever you open an account up like that. And obviously life insurance is a beneficiary. Now, if on all of those things, you can always leave that to an institution. You don't have to name a person. So again, a charity, a church, anything that you want to leave money to, you can do that directly by naming them as a beneficiary on those accounts. So another thing, actually they gave a little example here, and I think this is kind of a cool example. It's an example of a lady named Jane, and we'll go over that real quick. I think I have it somewhere here. It's Jane. Here we go. So just to consider her case, and this is how, just to reiterate how important it is to occasionally, I would say once every couple of years, kind of look back and see who you have named as beneficiaries and make sure that everything's going to who you want it to go to. But consider the case of Jane. So here's where it is. She had an outdated 401k plan beneficiary, and then her wishes might not be carried out. So here's what happened to her. When she first enrolled in her 401k plan, Jane named her children as primary beneficiaries. Now, in a lot of 401k plans, if you want to name somebody other than your spouse as a beneficiary, your spouse actually has to sign off on that because you're supposed to leave a spouse unless they sign off on it. Well, her husband agreed to her designation and consented to her giving her money to her children. Well, unfortunately, her first husband passed away, had an untimely death and passed away, and eventually Jane remarried. What she did is she forgot to update her beneficiaries on her 401k. Upon her death, meaning, so she still had her children named, but upon her death, she was remarried at the time, and her husband had not signed off on the fact that he was not the beneficiary on the 401k, and he was able to legally claim the rights to those dollars. So that's just an example of someone. and why it's important just occasionally to step back and take a look at that and make sure you're renaming the people that you want your assets to go to as beneficiaries. A couple considerations when you're thinking about beneficiaries. First of all is not naming people that are too young or too old. So you need to think that through, because if you have a 15-year-old son that is in a time in his life where he's kind of crazy and having fun, and all of a sudden something happened to you and he got a windfall of a $100,000 401k or something like that, you want to make sure that you're leaving it to somebody that you feel like has the capacity to make the right decisions that you want them to make. And then also, is somebody maybe too old to name as beneficiary? If you have, your parents are in their 90s and they're a beneficiary, are they really going to be able to benefit that much from inheriting those dollars? Or would you rather those go to somebody that might have more time or ability to utilize those assets in a different way? Another consideration is, and I've hit it a couple times, you can leave trusts, charities. So if you own a trust, you can name that as a beneficiary. If you have a charity you like, you can name that as a beneficiary. You can name a church as a beneficiary, or any of those. Another thing is what they call per capita or per stirpes, and some of you have probably heard of that before. But when you name a beneficiary, you get to choose whether it's per capita or per stirpes. And I'm going to try not to butcher this and give you a little example of what that would be. But let's say there's a father named Jim who has 3 sons, okay? And each one of his 3 sons has 3 sons. Let's just make that, or has 3 daughters. We'll make it even. How's that? So we've got a father, 3 sons, and each one of his sons has 3 daughters, okay? If the father wants to be per capita, wants to give money to each one of his kids per capita, that's giving each one of them 33%. Well, if you name per capita, what happens is if one of his sons passes away, as opposed to the money going to the son that passes away's kids, it would actually split in equal shares to his other 2 sons. So if you're per capita, you're naming the beneficiaries, and if one of those beneficiaries dies, their share is going to go to the other beneficiaries. Now, if you name them per stirpes, what that means is that the same situation, if one of them passes away, as opposed to that one shares equally going to the other 2 beneficiaries, it's going to follow the lineage, and then his 3 daughters would inherit those dollars. So I know it's hard to think about your beneficiary passing away before you do, but that is something to think about, whether you want them to go per stirpes, especially if you have grandchildren, because that can certainly be a source of family tension if that's all not named correctly. And I think really when it comes to estate planning, that is really half of the battle. Half of what you are trying to do is avoid having, family fights and blow-ups and people fighting over things upon death. So, and we've seen that happen too. And I think Brad was telling me yesterday, he's seen that happen at the church too, where someone passes away, things aren't in line, and not only are you dealing with the death of one of your loved ones, but now all of a sudden, you're with your siblings and you're fighting over who goes where and what goes what. So anyway, that's that. Naming beneficiaries. Let me see where we're at here. I'm going to skip this one because we already talked about that. So about updating your beneficiaries. I think I hit that one pretty good. So we'll move on here to wills. So a couple of things that you can do. There's wills, trusts, and they're different. Okay, the simplest way to make sure that people that you want to get your assets do is to do a will, and it's the cheapest way too. You can go to an attorney and get a simple will done, and a lot of times you can actually go online and get a simple will done for really cheap. But if you go to an attorney, which we usually recommend going to an attorney, just because it's a warm body that's kind of talking you through everything to make sure that you know what you're doing. But you can usually get a simple will done for anywhere between $400 and $1,000 to have everything lined out. And then you might have to update that will every 10 years or so. But in a will, the first thing that you're going to do is you're going to name an executor and a guardian, okay? So the executor is the person, if you pass away, they're the ones that is going to be responsible for administering your estate and making sure that making sure that everything happens to your wishes. So there's the executor, and then you also need to name a guardian if you have children. you need to name a guardian, and I would very highly recommend talking to the person that you're naming a guardian prior to naming them a guardian to make sure that they want, that if something happens to you, they're willing and able to take care of your kids in that point in time. So that's one of the things the will is going to do is you're going to figure out who's going to handle your affairs, and you're going to name a guardian. And then it's also going to spell out the distribution of your assets. So you might have a home, you might have an IRA, you might have a brokerage account, you might have a car that's near and dear to you. Anything that you want to name to somebody, you can spell out exactly how you want that distributed upon your death in your will. And the other thing it's going to do is it's going to help avoid state involvement, like what we had talked about. The state's not going to have the opportunity, you're not going to fall into their laws, and they're not going to get to choose who gets what out of your estate. So that's the simple form, the easiest way to avoid those issues. Now, one thing about a will is that it does go through probate. Okay, so probate, actually I have the exact definition of probate here, and I'm going to give that to you. So probate is the legal process by which your will is proved valid in court. So when you have a will, it's going to go through probate, and what they're doing basically is at that point in time, you're probably going to have to hire an attorney. It's not extremely expensive, but there is some expense there. And it can take the court, I've seen it 2, 4, 6, I've seen it take a year for the court to actually settle an estate as it goes through probate. So just know that whenever you do just a simple will, there's nothing wrong with doing just a simple will because it's going to get your assets where you want them to go. The only problem with it is just know that you're going to have to go, whoever your executor is going to have to go through that probate process. And like I said, there's a little additional cost and it can take a little bit more time. And then the executor is responsible for settling the estate. And actually, I think there's a deal here that talks a little bit about the executor's duties, and that's actually later in the presentation, so I'll keep going here. So that's probate. You have to prove that your will is correct, and it takes a while to go through the probate system. There are ways to avoid probate, okay? It's a little bit more expensive from a planning perspective to avoid probate, but it can be done, and the easiest way to do that is to have trusts. Set up for yourself. If you have assets that are owned inside of a trust, they skip the probate process and they go directly to the beneficiaries at that point in time. Now, if you're looking at a full estate plan where an attorney's going to do trust, you could be looking more toward anywhere between $1,000 to $3,000 expense. So it could be a little bit more money for you. So that's something that you just have to weigh as to whether that's important to you to avoid that probate process. Another way, we hit on this earlier, is you can give gifts during your lifetime. So if you give gifts during your lifetime, that's going to avoid probate because those assets are already out of your estate because you've already gifted them to somebody else. Another thing that you can do is own an account in what they call joint ownership with rights of survivorship, if any of you guys have ever heard of that. But what that is if two spouses, say, want to open up a joint brokerage account with rights of survivorship, what that does is if one of the spouses dies, the entire account automatically goes to the surviving spouse. So that is a good thing. One thing that I will say, and we run into this all the time, and a very, very simple way to avoid some of your assets going through probate is if anybody has a brokerage account, a bank account, anything out there that's not in an IRA or a 401k, is to name what they call either a transfer on death or a payable on death, TOD or POD. And what that does, it's basically the exact same thing as naming a beneficiary on your IRA or your 401k. The problem is when you go into a bank and you open up an account, they never ask, hey, do you want to put a TOD on this? Because on an IRA, you're required to name a beneficiary. You're not required to name a beneficiary on any account that's not an IRA. So whenever you do that, just keep that in mind. It can really, really simplify your life or your survivor's life if you name a TOD or a POD on any account that you have that's not held in an IRA. And then we already hit on retirement plan beneficiaries. So any of that stuff, meaning a 401k or an IRA that you put a beneficiary on is not going through the probate process. It's skipping that process. Any account that you have a TOD or a POD on is skipping the probate process. Any joint ownership account that you have is skipping the estate or the probate process unless both of you pass away at the same time. So you might want to name a secondary beneficiary on that TOD account in the event that that happens. And then anything that's held in a trust or that you gift out during your lifetime is going to avoid that probate process too. So now talk a little bit about the executor's role. So the executor's role is to, like we said, to settle the affairs. I wanted to go through kind of some of the duties of what a typical executor does, just so that you will know that. So let's see. Here are the duties. So deciding whether or not probate court proceedings are necessary. So they have to go through your list of assets and decide, okay, well, this has a TOD, this does not have a TOD, this is in a trust, this is not in a trust, and decide which one of these, what of your stuff needs to go through the probate court. And then also with that, actually finding out who the beneficiaries are and figuring out who inherits what property. If probate is required, you have to filing the will and all required legal papers in the local probate court. So you actually have to go to court and file to settle that estate. You have to find the deceased person's assets and managing them during the probate process. And then you have to handle the day-to-day details, such as terminating someone's leases, turning off their cell phone, making sure their credit cards are shut down, handling government affairs like Social Security. So it's just all the things that you don't think about that need to be done after somebody passes away. That's what the executor is going to be on the hook for. And another great tip here that they have is review. Make sure that the person that you name as executor wants to be the executor or is willing and able to be the executor on your estate too. And you might want to, and we're going to go over this here in a few minutes, is to review with that person. And we're going to show you one of the things we've had done for a few of our clients, which I think is a really, really good idea. And we're going to hit it here after we go through some of this other stuff, is to actually have a safe, little safe that has all of the important documents that somebody needs to have in the event that something happens to you. Because that's a really good way to, and let whoever your executor is know where that safe is held and how to get into it. So we're going to go through that here in a minute. So that's executors. Talk about trusts. So we talked about trust. The greatest thing about a trust is that it avoids probate. Now, that's the simplest part about them. Trusts can go so in detail, and there's so many different types of trusts. But the big deal is they avoid probate. They can help you with tax planning, and in certain circumstances, they can protect some of your assets. So let's go through that. So two very basic types of trusts. And for each one of those, there's a million different subcategories. Let's just talk about the two basics, one of which is revocable, the other one is irrevocable. And they're actually kind of exactly what they sound like, which is in a revocable trust, it can be changed. And a revocable trust does not require its own tax identification number. So if I open a revocable trust today in my name and I put a brokerage account, say there's a brokerage account with $200,000 in there and you put it into that revocable trust, well, you have the ability to change your mind on anything that you do inside of that trust. And the income taxes. So if that $200,000 is in an income producing asset that's maybe giving you dividends every year that create a taxable event, well, that tax ultimately flows back to whoever opened the trust under their own Social Security number. So meaning I'm just anything that's in my trust, I'm filing on my own income tax at the end of the year every year if it's a revocable living trust. Now, if it's an irrevocable trust, and these are, I would say, less common than living trusts. Living trusts are very common, and they're that's what most people use as an estate planning tool. When you get into, usually it's higher net worth individuals, you'll be looking at irrevocable trusts. What an irrevocable trust is it's its own real entity that has its own federal tax identification number. So when you give money over to an irrevocable trust, as long as that money is in that irrevocable trust for 3 years prior to you passing away, that's actually not part of your estate. You don't, once you give it to that irrevocable trust, you don't own those assets anymore. You name a trustee on that trust, and they technically at that point in time, the beneficiary of that trust, own those assets. But it's a really, really neat estate planning tool for people that are over those high net worth thresholds, because it allows them to get money out of their estate, go to where they want it to go to, and not have to, not have to pay estate taxes on them. Because they're also, if it goes through an irrevocable trust, it can be exempt from that estate tax if you're over those minimum thresholds. So those are the two basic kinds. I would say 95% of the time when we're dealing with clients and we're managing money for them, we're managing them inside of a revocable trust, not an irrevocable trust. And another word for a revocable trust is just a living trust. You retain full control of the assets as a trustee, meaning you can be your own trustee and you have full control over everything. And again, it still avoids that probate process. So if you pass away, someone can prove a death certificate for you, those assets are able to be dispersed without going through any sort of probate court, which can be a lot easier. So types of trusts, I'll just briefly hit that. Life insurance trust. Now this is one. A life insurance trust is used for a couple of reasons, one of which is what I talked about, where someone's trying to build a trust that's going to give heirs money in order to pay off estate taxes. Another reason people use these is if they want to give money to either a charity or a church. These are great. Life insurance trust is a great way to do that, even if it's a life insurance policy or a life insurance policy inside of a life insurance trust, where you can actually make premium payments to that life insurance policy and get a tax break today. So let's say you wanted to buy, let's just take Crossroads Christian Church for instance. Say you wanted to buy a $200,000 life insurance policy, and you're going to make payments or premium payments to that policy that are $1,000 a year. Well, that $1,000 that you pay into that premium is actually tax deductible to you in the year that you make that premium payment. And then every year you make the premium payment, and then upon your death, whether that's 5 years from now or 35 years from now, that life insurance proceed pays to the church if they're named the beneficiary, or the charity that you want to name it to, or the individual that you want to name it to. So those are a great way to leave money. Trusts for minors. So a lot of you have heard about, say there's somebody that has money and they want to give it to their minor children, but like we talked about earlier, they might not be overly confident in their minor child's ability to make good decisions with a windfall of money at this point in time. So what they want to do is build a trust that's going to pay out over certain times in the future. And so you can do that. And there's also, with those, there's also disability trusts, or special needs trusts is what they're called. So if anybody's dealing with special needs children, there's really good ways to make sure that if anything ever happens to you, that the special needs child that you're able to pay for the necessary care for that child as well down the road. And then there's charitable trust, also qualified personal residence trust, which is where you can actually put your house inside of a trust to avoid the probate process, which they have those. You can also put your house inside to a living trust as well if you want to do that, to leave that without going through probate. So lastly, what we're going to hit on here, we're getting closer toward the end where we can answer some questions, and I think Eric's going to talk a little bit about this safe that might be a good idea for you to think about with what documents are important. So what an alternate decision maker is what would happen if you couldn't handle your own affairs? Meaning, if you're medically incapacitated, or if you were to get some sort of disease where you can't make mental decisions on your own, or if you're physically impaired to the point where you can't make decisions on your own, you need to name somebody, a couple of people, one of which is the power of attorney. The power of attorney is basically giving somebody the right in your incapacity to make decisions for you. You know, whether that's whether to sell your house, whether to think of any decision in the world, they have the right to sign documents and make decisions for you in the power of attorney. But in that power of attorney, that doesn't happen unless you are incapacitated, and you can make sure that that doesn't happen unless you're incapacitated. And it says it takes effect upon implementation or when a specified event occurs is when somebody would have legal power of attorney. So inside of a will or a trust or whatever you're doing, you want to name somebody as your power of attorney. And a lot of times it's going to be the same person that's going to be the executor or executor of your estate. It's going to be somebody that you trust to make good decisions and decisions that are in line with what your wants and wishes are. And then lastly, there's also healthcare directives. That is basically giving somebody the ability to make medical decisions for you if you're not able to make them for yourself. So you want to name, and a lot of times, again, this might all be the same person who's going to be the executor, who's going to make the medical decisions for you, and who's going to be your power of attorney. But again, very, very good idea just to sit down with them and make sure that that's something that they're willing and able to do. So I'm going to kind of skip that part. So now we're going to talk about how to get started. Okay, if you are in a position where you know you need to, either you have an estate plan that's outdated or you know you need to get one, we're going to give you a simple checklist, and it's actually on page 3. You'll see just the documents that are recommended, which would be birth certificates, marriage, divorce certificates, pension records, real estate deeds, car titles and registrations, cemetery deeds, all that stuff. And Eric, I don't know if you have a mic. I don't know if you want to touch real quick on Eric will touch a little bit about one of the things that we recommend doing is show you can go get one of these safes. How much are these things? Probably $20.
Yeah, $20 at Walmart or Target, just a safe. And we were introduced to this about 4 years ago, and just an idea for helping individuals and certainly family members and other clients with getting things organized. And I know on that list it's got a lot of different documents, and what we do is we break them up into a red category, a green category, looks like a light blue, a dark blue, and then a brown category. And the red category, for instance, is health. Without getting too personal, raise your hand if you have a prescription, or maybe a spouse has a prescription. Yeah, most of us do. I do. My wife does. I have no idea what prescription she actually takes, what dosage she takes, and if something were to happen to her, and for instance, God forbid, a car accident, and then I have to go in and the doctor asks me, what is she taking? I might be able to be pretty close, but I have no idea what amount or what dosage. All I'd have to do is just go home, go to our safe, grab the red files. It has all the documents in there for what she's taking, when she takes it, and so on. It's very simple. You just rip off the tag when you go get your prescription filled at Walgreens or CVS. Just put it in the red folder. Also has, obviously all the financials, bank accounts, investment accounts, and then life insurance. Probably a lot of life insurance policies that might be, with a work or if you retired from there. Sometimes they even have a life insurance policy that stays with retirees. But the brown category is another category that not a lot of people think about. That's website passwords, membership subscriptions. Again, I think you mentioned cell phone. What's your phone number? Now, you don't even need a password to get in your phone. You need a thumbprint. That would be very difficult to get into your spouse's or someone you love's phone with their thumbprint if they're not around anymore. But then obviously the other credit cards, like I said, marriage license, other loans, partnerships, and unfulfilled responsibilities is another list. So what we'll do with individuals, like I said, it started with myself doing this first with me and my wife. We took about 18 months to go through all these different categories, one at a time. We did not want to rush it. It wasn't something that we needed to get done in the next 2 or 3 weeks, because it is a long process, but at least gets us organized. We know we have a key. We know a couple of her family members know where the keys are. And like I said, they can go in if there's anything that they need from us, our will, trust, everything is in there, and it's locked away safe. So that's something that we can discuss a little bit later, as far as the more intricate details of the kit.
Yeah. So, but that is, and I would say too, what he said there with the bank or just your passwords in general. I know if something happened to my wife and I need to get that in line, I wouldn't know, I wouldn't know how to get into certain accounts that she has and stuff like that. So it can be as simple as having a statement in there, but then like he said, having if you have all your passwords, they can log right in and get to anything that they need to get to. So, but that kind of concludes the presentation, and I hope this is kind of estate planning at a 30,000 foot view, meaning it's definitely looking at it from a pretty high perspective, and it's a lot more detailed when you actually sit down and go through the process. But I would recommend, there's a couple places that you can start. One of which is if you have a financial advisor, whether that's a CFP or just somebody that works at XYZ brokerage, most of them have estate planning attorneys that they'll refer you to. And I know that we certainly have about a list of about 4 of them that we refer our clients to. If you guys need a referral to an estate planning attorney, let us know. And I will say another step in the process with estate planning is just there's a lot of people that we run into out there. You might have 5 to 10 different, or maybe 3 to 5 different IRAs or old 401ks from old companies. Sometimes the first step in the process is actually to go see your financial advisor prior to seeing an attorney, because before you go like name who's going to be the beneficiary and who's going to be in the trust, you might want to just consolidate everything so that you don't have 5, 10 different accounts floating out there in various places, because just simplifying your life that way can certainly help as well. So other than that, I've been up here gabbing for about 45 minutes, and I certainly appreciate the time. I'd love to take any questions. If you have questions for any of us, I know Eric and Sean both have a microphone too, and if there's any questions, we'd love to take them. If you don't want to ask a question in front of everybody, we're certainly going to hang around here for a few minutes afterwards and be happy to talk to any of you guys about any questions that you have. So, any questions? Yes, ma'am. Actually, hang on one sec. He's going to give you.
When you talked about the rights of survivorship under the joint ownership,
Yep.
What does that include? If it doesn't include the bank accounts that you would do, the TOD and the POD, and it doesn't include the IRAs and stuff like that, where you've already named your beneficiaries, is it your house or something like that that you want to make sure that you have that on?
You can do that with your house, and what I would say is, hopefully I was clear there, you need to do one or the other, meaning if you have a TOD account, then it's not as necessary to have it a joint account. But if you have, what I'm saying is that if you have accounts out there that don't have a TOD and are not joint, you should do one of the two. Either decide, hey, we want to own this property together, and it's going to be joint ownership with rights of survivorship. The downside of that, realize, is that either person can make a decision on that account. So if you got to trust your spouse to do that stuff, because if you have a brokerage account and they're, they now have the authority to call in and make a stock trade or liquidate some funds at that point. So if you want to keep that ownership separate from you and your husband or spouse, then what I would do is do the just do a TOD, where if anything happens to you, then it goes to them. But if you guys own property that you think can be held jointly, hold it in joint ownership with rights of survivorship. And then if something happens to one of you, the next person just moves. It goes to the next person. But even if you do joint ownership with rights of survivorship, I would still do a TOD or POD and name the beneficiary in case something happens to the both of you at the same time. So, does that answer your question, hopefully? It does? Okay, good. Yes, ma'am. You can. Yep, you can. I know on our TOD account, it lists out there's 6 different spaces, and you get to name the percentage that you want each one to get, each beneficiary to get. So, yes, ma'am. Yep.
Okay, what happens, sorry. What happens if a situation in our family was we had a family member that was in a nursing home under Medicaid and passed away, and after she passed away, they wanted her house. Well, she didn't have a house. But if you do have a house, is that house protected in the trust or?
My inclination would, well, the first inclination would be to say, talk to an estate planning attorney, because I don't know for sure. But I think that you can set that up to where it is protected. Usually when you do that, if you deed any piece of property to an irrevocable trust, as long as it's held in there for 3 years, then it is creditor protected, and it is out of your estate at that point in time. So if you deed it to a trust, and then you go to a nursing, and then you die a year later, it's as if the trust never existed, basically, because then everybody would just be, when they realize that they have a problem such as that, they're going to go ahead and try to build a trust and deed it. So the rule is typically it has to be out of your estate for 3 years, and then it is. But again, that is advice that I would say I'm 90% sure I'm accurate on, and I would, whoever your estate planning attorney is, I would ask them exactly how that works. So, any other questions? Nope.
Hey, Jeb.
Yes, sir.
I've always wondered too, and I know we've gone through estate planning before. We need to update ours as well.
Yep.
But I know a lot of people do personal lists
Mm-hmm.
for things that they want to go to certain people. Are those legal and binding unless you actually make that a part of what your estate planning is?
So the list is not, unless it's a will. So a will is a list like that. I don't know exactly do you know, Eric, how far a list has to go before it's deemed a legal document?
Witnessed by 2 people, non-interested, and notarized is what we were told.
Okay, so there's your answer.
Yeah.
So I guess you could do it that way. The recommendation would probably be to take it a step further.
Yeah.
Even go online. You can go online and do a will for cheap, pretty cheap online. Any other questions at all? No? Well, we're coming on an hour. So guys, thanks so much again for having us out, and hopefully this was helpful for you. We're going to be hanging around for a little bit, so if anybody has any questions, certainly feel free to come over and ask them. And from there, do I turn it back over to you, Brad? Okay.